Thank you for that introduction. I'll be speaking to you briefly on the role of notaries in Belgium as far as real estate transactions are concerned. I myself, so my name is Frederick Helsen, as Glenn said. I'm a postdoc assistant at the University of Leuven and a candidate notary at Berkin Notaries here in Brussels. And I'll start off with a brief note on the role and position of notaries in Belgium, because as you've said, internationally, the word notary or the role notary can cover different kinds of professions. And it's important to know what we do and what we don't do so that we can have an effective cooperation. So we are impartial professional lawyers and public officials at the same time. So we're kind of a hybrid. On the one hand, we are an independent service provider. So notaries and candidate notaries or notary collaborators, as they are known, which I am myself. We are independent service providers who service our clients for a fee. On the other hand, we are also, or notaries are also public officials who have vested in them a certain segment of the power of the state. They are considered public officials in that they can give authenticity to certain things, meaning that the deeds they sign have a higher probative value. For instance, the main part being the date, the actual date of a certain person appearing before a notary cannot easily be challenged afterwards. It's considered a legal fact. And notaries have a certain monopoly for certain types of services. So we're kind of in between. On the one hand, the notary does work for you. On the other hand, he also has to serve the state. In total in Belgium, there are about 1,600 notaries who service about 2.5 million clients every year and sign about 1 million authentic deeds every year. So there's a fair amount of work going on. It's important to know that notaries do mediate, but they do not litigate. Notaries only work in non-contentious matters. They can be implicated in contentious matters such as divorces or tough negotiations on the purchase of real estate. And they will mediate in order to reach a solution, but they will not litigate or advocate on behalf of their client. It's a bit of a balancing act sometimes. Notaries and their staff will try to reach a solution, but they, for instance, will not engage in commercial negotiation. For that, you would need a real estate agent or an attorney. What we will do is advise on the consequences of certain types of or courses of action, and leave the choice up to you. But we will not advocate on your behalf. So notaries have a certain role to play in the Belgian legal landscape, and they deal with real estate law, which is what I'll be talking about mostly tonight, as well as family law and business law. I still mention the other two because it shows that we try and have to keep a broader view. And the three can be related. So for instance, if you come in for a real estate transaction, we will also look at the family law implications of what you're doing. We'll look at your marriage contract if you buy in your personal name, and discuss whether or not your marriage contract will need to be changed, or whether or not you wish to make a last will and testament to cover certain estate planning issues. Same for business law. Notaries are involved in the incorporation of limited liability companies and modifications of their corporate charters. So if you should buy with your company, we will also handle that end of the deal and advise on whatever corporate housekeeping this might entail. A very important point for any potential clients is, of course, the fees. Notaries, as I said, are independent service providers, and they definitely are when it comes to who pays for their services, because the clients do. Notaries do not work for free, and they're not paid for by the state. However, the notary fees are regulated by the state. So essentially the fees are all the same. All notaries cost the same. The only difference is in the administrative expenses, but that's That's a fairly limited amount, and the difference is minimal in and of itself. But the fees themselves, the salary, if you will, is the same. So there's no differentiation on price. There's no undercutting. There are no cheap notaries. We can only differentiate on service. So there's no point in asking for a discount, because notaries are not allowed to even give them. The only thing that you can strive for is to offer the best type of service. And the idea is that notaries can always be impartial, can be independent advisors, inform their clients impartially about their rights and duties, about the consequences of what they're doing legally, financially, tax, fiscally, and tax related matters, so that at the end of the day, they can do what is right for the client and not necessarily what is right for their wallet, or what might be detrimental to the interests of society. So let's get to the main point after this brief introduction of tonight, and that is talking about real estate and transferring, buying, or selling real estate. So when you want to buy or sell real estate in Belgium, you will necessarily at some point have to appear before a notary and involve a notary in drafting the documentation, in drafting the transfer deed. And the notary will have to put together basically a due diligence file. We will start a bunch of searches of various types, up to, let's say, about 100 of them. There are more and more databases available with more and more information, which we always have to check to make sure that everything is in order, and to basically look for things that might at some point go wrong, or have a detrimental effect to the interests of the purchaser. And the idea is that we sort of guide you through the woods. We provide for advice. We help you navigate the waters of all of the legal sides of real estate law in Belgium. So we do searches on the property. We look through the property title to make sure that the seller is actually the owner and is capable of selling actual property to you. Makes sense. But we also look for encumbrances. Are there easements? Is there a right of way that would go right through the yard of the house that you want to buy? Is there any type of limitation on what you can do with this property? We also look at what is known as the soil certificate. So environmental law, is there pollution, or is there a presumption of pollution on the property? Is there an obligation for a cleanup, or might there be in the future? We also look at zoning information, so the town planning information, which we request from the town or the commune where the property is located, to see if there's any zoning violations, what kind of permits were issued in the past, what kind of limitations you might have in the future, such as if you want to have the possibility to construct a swimming pool in some types of areas, you are not going to be allowed to do so, period. In other types, you might be allowed, but you'll need a permit. So we can advise on that. We also look into the seller, obviously, whether or not he's the actual owner, whether or not he's legally represented. Let's say it's a corporation. Let's say there's a minor involved. All kinds of issues can pop up. So we have to make sure that all this is in order, so that you, as a purchaser, actually get the purchase validly your property. And we look into the buyer, and we make sure that that the buyer is properly represented. And we advise on potential planning ideas, such as, for instance, a split purchase, where typically parents, let's say parents want to, or a couple 60-something wants to buy an apartment at the seaside. We might advise, if they deem fit, that the parents will buy usufruct and the children will buy bare ownership, funded by the parents in the right way, in advance, with the right documentation, so that there will be no inheritance tax when the parents come to pass away, and the children will obtain full ownership of that apartment. Typical type of structure at the buyer's end. So there's a bunch of searches that we have to do. Most of them will never actually tell you about in much detail because they'll have turned up blank or nothing particular to report. But these things are getting stricter every day. One very important one that you need to be aware of if you plan to sell real estate is the town planning legislation. Specifically, the fact that you have to get a town planning letter or certificate from the commune before you can even advertise your property for sale. So if you involve a notary or a real estate agent, then they'll advise you to do so, and they'll make this request on your behalf. But that information needs to be requested before you advertise the property for sale, and it can take a while for you to obtain this information. In Brussels, it tends to go up to 3 to 4 months in some of the 19 communes. Sometimes it gets even worse than that. After 30 days, you are allowed to advertise, but it's still going to be an open point when you've hopefully found a potential purchaser, because they are going to want to see this information. So this is one search that you have to start as early as possible. And in Brussels, you have to describe briefly, it's called the descriptif sommaire, so a summary description of your property in your request. Basically, they want you to declare any type of zoning violation that might exist. You have to describe what the house looks like. They'll compare that description to the permits they have, and they'll try to figure out if there's any mismatches that might be a zoning violation. So this stuff gets stricter by the year. As a purchaser, it's very important to look over this summary description and to match it with the factual situation. When you visit the property, you have to make sure that the way it was declared to the town planning authorities actually meets what you can see during your visit, because otherwise maybe somebody is trying to hide something. So that's the due diligence information. Ideally, we prefer to be involved as early as possible, both at the seller end and as at the purchaser end. When you're selling, just to get the necessary searches in time. When you're purchasing, just so that we can go through everything and flag any potential issues before you actually commit to something. And committing to something usually happens in 3 stages. The first stage usually is an offer. You're not, you do not necessarily have to make a written offer. And any written offer is always going to be very limited in what it can do for you. That being said, we understand that sellers want to have something in hand as soon as possible. And putting together step 2, the private sales agreement, usually takes a fair amount of time, because a private sales agreement usually is anywhere between 25 and 40 pages long. And so people want to tie things down a bit sooner, usually, which I fully understand. So if you have to make an offer, my advice is consult your notary to help you in making that offer. And be aware of the fact that an offer is a limited instrument. So an offer typically is 1 or 2 pages. It's going to very briefly outline the main conditions of your offer. I would like to make an offer for that particular house. I will offer, let's say, 500,000 euros. And we'll do so under the following conditions. And then there will be a brief list saying the land can't be polluted and there can be no zoning violations. And I also want to have the suspensive condition of obtaining financing, meaning that if banks refuse to finance this purchase, that I can get out of it without having to pay an indemnity. So this is going to barely cover the main issues. And in order to make sure that those main issues are at least barely covered, I would advise you to consult a notary. Because once you've made that offer, strictly speaking, once it's accepted, there is a contract. An offer was made, it was accepted, the object is clear, that constitutes a contract, and both parties are bound by it. That is the theory. However, that brings me to the second caveat that I made earlier, which is you have to be aware of the limitations of such an offer. It is going to be very short, and a lot of parameters won't be fully covered. So even though theoretically, it is a contract which is binding. There is a lot of consumer information which will not be covered, which is mandatory, and which will give a purchaser a way out. For instance, if the zoning information was not made available to the purchaser prior to making his offer, then strictly speaking, he can get out of it. Same for the soil certificate and soil information. In practice, if all of that turns up blank afterwards and there's no real reason why the purchaser would invoke this information to get out of it, then it's debatable. But in any case, you'll be in a situation where there is a lot of discussion. And the main problem with an offer is there's a lot of gaps. It's a very light document, literally and figuratively. And most people in reality just don't want to go to court holding nothing more, with no more ammunition than that light, simple offer. So an offer is a good way to kind of pull the parties closer together to make sure that there is some seriousness on both sides. But if you've signed an offer, the seller has accepted it, and then he wants to walk away from the sale, or vice versa, in reality, most people aren't going to go to court over it. And in reality, mostly those people will just walk away with no consequences. So if you want to make sure that you have something that is actually enforceable and that scares people into sticking with it, you need a full-on private sales agreement. The full, it's called a compromis de vente in French, compromis in Dutch. That too is not mandatory, but it is standard practice. And as standard practice, a 10% down payment is asked from the prospective purchaser. That down payment, very important, is not paid to the seller. If you want to buy real estate and the seller says, I want a 10% down payment, fine, but you do not pay the 10% directly to the seller. You pay it to your notary or the real estate agent, who will keep it in a separate account in the purchaser's name until the actual authentic deed, step 3, is signed. The reason we don't actually hand out the money to the seller is because there is a risk that they might turn up insolvent, or they could just disappear and not even turn out to be the actual owner of the property. So that's why it's held in escrow. It's blocked in a separate account until all of the due diligence is completed and we can close the transaction. But it does give extra leverage to the seller, because once that 10% is put in escrow with, for instance, the notary, and the private sales agreement is signed, then the purchaser can still decide to walk away and bank on the seller not going to court, but the seller can then claim that 10% as an indemnity, because all standard private sales agreements have a 10% indemnity clause, which cuts both ways. If the seller wants to walk away, then the purchaser can claim the same 10%, but there's no escrow amount, which is conveniently held and easy to grasp. That is step 2. By then, things have gotten pretty serious. People are transferring a lot of money, 10% of the sales price. There has been a full, or let's say 95% due diligence on the property. Property title has been checked. Any kind of easements, town planning information, soil information, everything is checked and looked over and put into this private sales agreement, so people know exactly what they're doing. And then we go to step 3. The reason there's some time between step 2 and step 3 is to allow the purchaser to take this signed private sales agreement to the bank, to Dave or whoever at ING or some other bank, and ask for their financing, because banks usually want to see a signed private sales agreement to know that this is a real thing before they put in the effort of putting together a financing package. Secondly, during this intermediate period, we do some more checks. We make sure that the seller is actually still the owner up to the day of the deed. So we do need a little more information before we can go to the actual authentic deed, the sales deed, the acte authentique or acte notarié. And that is the one that you actually do need. That one is indispensable, because that is the only instrument that you can take to the mortgage office and have recorded. And a recorded purchase or recorded property deed is the only way to actually be the owner of real estate in Belgium. So that's why you have to go before a notary. The notary draws up the deed, you sign it, the notary authentically, so having additional powers of proof, establishes the fact that there is a sale, that person A sells property X to person B, and then has this deed recorded at the mortgage office. So at the end of the day, parties are hopefully, or they should be, very well briefed about what they're doing. Um, and the main interests of what they're doing should be covered. You will actually become the owner. If there's any encumbrances against the property, at least you'll know what they are so that you can act accordingly. A small note on loans and mortgages. In practice, banks rely on notaries to make sure everything is in order. So they won't bring in their own counsel. They will agree to have the credit deeds, the mortgage deed, the mandates signed by your notary of choice as a purchaser. And they just look at us to handle the money, to handle the mortgage, make sure that their rights are in order. And if they're not, then the notaries are just going to be liable. So that's close enough for them. Belgium, of course, wouldn't be Belgium if there wouldn't be a tax aspect to this type of thing. And of course, if you buy real estate in Belgium, there is a tax to be paid. As you probably know, Belgium consists of 3 regions, the Flemish, the Brussels, and the Walloon region, and the tax rates for buying real estate differ between those 3. The basic rate in Flanders is 10%. In Brussels and Wallonia, it's 12.5%. However, in Flanders, if you are purchasing your first home, which you purchase to actually live in that home, you can buy under a 6% regime. There's also a tax carry forward scheme, which is very complicated. But basically it means that if you buy a house, sell it, move to a different one, buy that one, sell that one, buy a new one, every time you can carry forward a fairly small portion of the taxes you paid on your initial purchase into the next one. So you can kind of recoup some of the purchase taxes that you paid on your first home. Only applies to your homes, only applies within certain temporal boundaries. There's a bunch of limitations. If you're in that situation, your notary is going to ask you a lot of questions and will calculate the actual benefit. So that's those are the kind of key points for Flanders. In Brussels, the basic rate is 12.5%, which is higher, but there is an abatement, the abattement, a tax abatement, meaning that the first 175,000 euros are exempt, which means you get a 21,875 euro discount. If the total purchase value does not exceed 500,000, and if it is your only main residence, it has to be your main residence, meaning you have to move into the property within 2 years, and it has to remain your main residence for the next 5 years. So there's a number of conditions there. I'll just take out the main ones. The maximum price of the property you're buying cannot exceed, or the total price cannot exceed 500,000 euros. Don't be tempted to try to split things up and to buy an apartment for the magical number of 500 or 499 and a parking space for 25,000 2 days later. That's just trying to evade taxes, and that's not a risk worth taking. You also have to move into the house or the apartment within 2 years and maintain your residence in that property for 5 years, not in the Brussels region, in that particular property for 5 years. If not, you will at least have to repay the benefit that you got, and potentially there will be a fine on top. And finally, this only applies if this is your only residence. People usually tend to say first, not exactly true. If you've owned a house before but you sold it, then you can still apply for this tax abatement. So that's registration tax. Unfortunately, it doesn't stop there. Things get a bit more complicated than that, because if you buy a new property, if you buy on a plan. If you buy something that has yet to be constructed or has very recently been constructed and is considered new for VAT purposes, then you will not pay registration tax, the 10, 6, 12.5%, but you will pay VAT, which is 21%. Unless and this is usually the case for newly built properties, if you go to a real estate developer and they have this fancy new residential tower in development that they want to sell based on fancy renderings, usually the land will be owned by one company and a second company will sell you the constructions. And in that case, you will pay registration duty or registration tax on the land value and VAT on the construction. Very simple way of saving just a little bit on taxes. VAT is 21%. However, there's a new, very recent COVID-inspired scheme that allows for the construction of new first residences and for selling those under a 6% VAT regime. Basically what it means is if you're looking to buy a newly built house or apartment from a professional developer or a professional contractor, and it is going to be your first residence, so you don't own any different residences and you are going to live there yourself, then ask the seller or your notary about the 6% regime, and they'll figure out whether or not it actually applies to your situation or not. So that's the main gist. I'm just going to go one last point on the abatement that I do want to mention because it applies to a lot of people. So the tax abatement in Brussels, the exemption on the first 175,000 euros, only applies if you don't own any other residential property in full ownership worldwide. So anywhere, if you own a house anywhere, you are disqualified, but it does say full ownership. So let's say you want to buy an apartment in Brussels, but you have half of a house in Germany or the UK, which you inherited alongside one of your siblings, then that does not disqualify you because you don't own a residence, a house or an apartment in full ownership that you could use to live in yourself. That's why you have to buy a new one in Brussels, and then you are allowed to benefit from the tax abatement. So those are the main points on buying or selling real estate in Belgium in the normal market, so to speak, in the private and unforced sale market. But there is a particular way of purchasing real estate, which is the public sale. Public sales in Belgium since about 2.5 years now can actually be done online. Basically, it's kind of like eBay for real estate. That was introduced about 2.5 years ago, and it's called Bidit, bidit.be. And it exists alongside the old school typical physical public auction that used to be the norm and that still exists, but less so, and with COVID even less so. And Bidit it's a great innovation. Like I said, basically it's eBay for buying real estate. So everything is posted online. There is one website, it's Bidit. It's hosted and organized by the Belgian Federation of Notaries, who organize the actual sale. So all of the benefits, all of the safeguards that the involvement of a notary brings are brought to the Bidit platform. And so, like I said, everything is posted online. There's pictures, there's a description of the property, and then there's a document called the conditions of sale, verkoopsvoorwaarden in Dutch, conditions de la vente in French. That is the most important document on that website. That contains everything. That contains all of the zoning information, the soil information, all of the searches. Everything is put in that one document, the conditions of sale, so that you have everything there, including the rules of the platform, the way the actual bids work, and what the fees are. Everything you need to know, you'll find in the conditions of sale. Now, of course, posting something online is all very well and good, but you want to visit a house or an apartment before you buy it. That makes sense. And so physical visits are, of course, still organized, even now under COVID, although with more restrictions and with less people at the same time. But physical visits are organized so that you can actually visit the place and ask some questions. And then let's say you found the house that you want to buy on Bidit, and you decide you want to actually put in a bid. Then you will be invited to do so through either a Belgian EID, so the Belgian electronic identity card, or a bidder profile. So if you don't have a Belgian EID, then you are kindly invited to contact the notary organizing the public sale through Bidit, and he will create a bidder profile for you. He'll verify your identity, ask for a copy of your passport, explain how things work, etc. And then he'll create a bidder profile, and that's going to allow you to make those bids. In practice, properties are posted to Bidit for a couple of weeks. There's some advertisement on different websites like ImoWeb or ImoVlan. Depending on what the seller wants, it can be advertised anywhere in newspapers or on Facebook, whatever you want. And so there's an advertisement period of a couple of weeks, including physical periodical visits. And then during an 8-day period, you are invited to make your bids. And of course, usually people wait until the last minute to actually make their bids. If you make a bid, or anybody makes a bid in the last 5 minutes, then the bidding period is extended for another 5 minutes. And during that extension period, only people who have made a bid in the regular period can still make bids. So if you want to get involved in extra time, you have to at least have gotten involved to some extent during the regular playing time if you want to be in the final end game. And then, usually in the last half hour, bidding starts to pick up, and then usually they get extended for a half hour, an hour, depending on how strong the bidding is, until in the end a final bid is reached. After that, within 10 business days, the property will be allocated to the highest retained bidder. And I say retained because, of course, it is the internet, and there are some people out there that basically do anything, even though they have to use their electronic signature and their EID, etc. You still get people that afterwards basically say, well, I didn't want it anyway. You are bound. Everybody is bound to their bids. And the seller can always decide to go after you, to claim your bid anyway, even though you decided you didn't want to, because you did sign with an electronic signature and you knew what you were doing, or you're supposed to know. So everybody is tied to their bids. However, in reality, sometimes the theoretically highest bid just isn't going to be plausible. It's not going to be realistic to claim. And the seller and the notary may decide to go for the second highest bid or the third highest bid. And those people are still bound to their bid. So this, very important. Let's say you have 2 properties that you're interested in. You bid on one of them because the second one is only going to expire 2 days later. You bid on the first property, you're outbid. Somebody else outbids you by €1,000. Don't necessarily start bidding on the second one just yet, because you might still be bound to purchase the first one until the property is actually allocated to the highest retained bidder. And everybody who made a bid will be informed of that fact. So at some point, you've made your bid, you've been outbid, but you're not sure whether or not that is actually going to stick, and they might not turn back to you. At some point within 10 business days, there has to be clarity for everybody, and the notary will allocate the property to the highest retained bidder and notify everybody else, you're off the hook. We have our highest retained bidder. It's not you. You're free to go and bid on other properties. So that highest retained bidder, and let's say that is you, within 10 business days, that person has to go to the notary organizing the sale in person to sign the allocation deed. I say in person. These days, in person is a flexible concept. We do have the possibility of creating digital proxies now, where you would appear before a WebEx meeting and use that same electronic ID card, which you then need to have. And the bidder profile does not work for a digital proxy. You sign a digital proxy with your EID, and then the proxy holder will sign on your behalf. But within 10 days, you have to sign that allocation deed, and that will basically make you the owner. From that moment on, you are the purchaser of that property. That being said, there are, of course, some financial ties to this whole operation. And that is kind of bifurcated in public sales, because things on the one hand have to go pretty fast. We have the 8-day bidding period, 10 business days for the allocation, because we can't have dozens of people tied to their bids for months on end. People need to have clarity as soon as possible, and usually the allocation deed will be faster than the 10 business days, usually be 2 or 3 business days. And usually that's a little too fast for people to come up with the type of money we're talking about in buying real estate. So in a bidded public sale, you are kindly invited, on pain of interest, to pay the expenses and fees within 5 days after the allocation deed, and the actual price within 6 weeks. The idea is the expenses and fees is a lower amount, and the total expenses and fees are, you will find the rates in the conditions of sale, and the rates have been created to be pretty much equal to a regular purchase. So what you'll see is a table of rates saying if the price is between this bracket or is in this bracket between this amount and this amount, then it's going to be this percentage. In this bracket, it's that percentage. Basically, those percentages add up to the registration duty applicable plus the regular notary fees for the purchase deed. And basically, at the end of the day, it's going to cost you, if you buy a house on Bidit for 300,000, or if you buy it in the regular market for 300,000, the total bill is going to be pretty much the same. That's the idea. The difference is going to be negligible. So those expenses and fees, which are going to be about, let's say, 10 to 13% in Flanders, and well, let's say 12 to 14% in Flanders, and 14.5 to 16.5% in Brussels, depending on the amount. That has to be paid within 5 days after the allocation. So you have to make sure that you have those means handy, through financing or your own means. Doesn't matter, but they have to be there within 5 days. And the actual mortgage that you might have to grant to the bank, that will not be ready in 5 days. So you have to have a pre-financing or your own means, but you have to make sure when you're making a bid on Bidit that you have the expenses and fees, which you can calculate it in advance using the rates that are in the conditions of sale. You have to make sure that you have those handy. And then you get a 6-week period to pay for the actual price. And those 6 weeks are designed to allow you to get financing, regular mortgage financing from a bank, maybe go to different banks and compare rates. 6 weeks is more than enough to handle that. And then after you've actually paid up everything, that is when you get the keys to the house and you get to actually take possession. I think that makes sense. You can't move in until you've paid the piper. So that is on the purchasing end. You might sit there and think, well, I have a house for sale, and this all sounds really good because this is real-time, online, low threshold, easy access bidding, and this sounds like the best way to get full market value. And usually, frankly, it is for properties that have a good traction in the market and that don't really need a specialized selling strategy or highly specialized selling strategy. Usually Bidit is a pretty good way to get full market value. So let's say that you decide you would want to sell through Bidit. Then my advice is go to your notary, tell them about this, and they will help you out. Total expenses depend on the selling price, because there are certain fees that are a function of the selling price, and mostly on the advertisement strategy. If you want to advertise in several newspapers and websites, etc., then that runs into a few €1,000 pretty quickly. If you are comfortable advertising it yourself on Facebook and all kinds of platforms, Twitter, depending on how many followers you have, and you decide that no additional advertisement is necessary, you just want to post it on Bidit, then it's going to be a lot cheaper. That really depends on the property and on what you want to do. But usually, as a rule of thumb, you can assume that it's going to be somewhere in the neighborhood of 2% of the selling price. So if that interests you, then all I can say is talk to your notary and they will help you out. So those were the more nitty-gritty, detailed mechanics of buying and selling real estate in Belgium at quite a pace, I am aware. But this stuff is complicated and there's a lot involved. And I did want to give you a fair amount of flavor. But of course, if you are in the position of having a real estate transfer in the near future, take your time to gather some information and to talk to professionals, notaries, attorneys, real estate agents, what have you. I'm just going to leave you off with some of the main numbers of the real estate market in Belgium. Activity numbers in 2020 are, of course, off by a fair amount due to the COVID crisis. Total activity numbers, frankly, I looked them up just to have them, but they don't really say much because obviously the amount of visiting properties was prohibited for quite a while, and it's still a lot harder. So that's taken a toll on activity numbers. More relevant, I think, is the average or the evolution of average selling prices. And I focus this on Brussels. You can get the other numbers online, of course. Real estate still rises in value or increases in value in Belgium. In Brussels, a house on average would have cost you €493,500, an apartment 269, up by 3, respectively 6%. And over 5 years, it's a 16 and 22% increase for real estate in Brussels. So it's a cliche, but Belgian people really like their real estate. They really like to buy real estate, and usually people assume that it's going to increase in value. And luckily for our sense of identity, so far it still does. If you want more information on this, there is a lot of information to be found on notaris.be or notaire.be in French. Some of this information is also available in English, but that's a little more limited, I'm afraid. You can check out the Baromètre des Notaires, the Notary's Barometer, which will have all of the numbers on price evolution and evolution of the amount of real estate transfers. And if you want to look into into the other matters that notaries help out with, family law, business law, there's a lot of information on those types of issues as well on the same website or on successioneurope.eu. That specifically is for estate planning successions. If you have any particular questions, feel free to reach out to me on my email address,